I want to follow up, Director Wray, about the Foreign Influence Task Force. So there have been exchanges with Mr. Johnson from Louisiana, Ms. Hageman over that, and I understand the difference. I want to respect the differences in characterization. Earlier this week, in denying a stay of its order, the federal court essentially said this isn't complicated. Follow the law as articulated by the United States Supreme Court in the area of the First Amendment. And that was it as far as it was concerned. The Foreign Influence Task Force is not a predecessor's decision. You set that up, right?
Yes.
Okay. And you've known about the continuous interaction with social media companies. You've known about, I'm sure you know about the testimony of Agent Elvis Chan, correct?
I mean, I don't know everything he's testified to, but I'm aware that he was...
Did you read his testimony?
I've read parts of it, yes.
Okay. And there were thousands of posts that were flagged to the social media companies. These meetings with social media continued across time on a periodic basis. And this court has found, and I understand where the point of disagreement is, I guess, at this stage is, but I believe it's fairly common sense, that if you've got a constant, expectant suggestions from the FBI to social media companies with respect to social media posts, at some point in time it becomes a government decision or it becomes coercive in nature. That's what the court's preliminarily found. You all, that apparently is the line you decided to walk in setting this up. Today, it's sort of striking that you come in and you sort of casually acknowledge that among other things that we did pass through, I think you said, information from the Ukrainian SBU to social media, as if it's normal for the FBI to serve effectively as the agent of a foreign power, to help pull information out of circulation to which Americans otherwise would have access because the Foreign Intel Service doesn't like it. Now, those are my characterizations. I have tried to be a little bit more neutral in my language, and you can differ with them, but here's what I'm wondering. Why would you walk that fine a line with respect to Americans' fundamental constitutional rights at scale, especially with knowledge of past abuses by the FBI like COINTELPRO? You said earlier that the FBI wasn't even concerned about disinformation per se, but the foreign origins of the information. Assuming so, how does that comport with Lamont versus Postmaster General?
Well, I'm not going to try to engage on Supreme Court jurisprudence, but what I can tell you is that the...
Well, I mean, that's the point, though, Director Wray. And let me just ask you, do you know about that case? Do you know that case?
I've heard of the case.
All right. Right in the heart of the Cold War, at the behest of an American plaintiff, a communist, by the way, the Supreme Court said that Americans have a First Amendment right of access to information, even if it is propaganda originating abroad. And in that case, the United States Postal Service could not interdict it. Do you know that, in essence?
Again, I'm not familiar with the holding of the case. I'd have to review it to be sure that that's a correct.
That seems to me the trouble. I keep wondering as I read all these revelations how that could be. Or then, let me go to this. You know that the FBI engaged with the social media companies, continuously warning them of hack and leak operations in 2020. Not 2018, by the way, but before the 2020 election. Lots of warnings about hack and leak. You're aware of that?
I'm aware that we gave them lots of information about intelligence that we were receiving from some of our intelligence
At the time you were giving them those warnings, the FBI had the Hunter Biden laptop for more than 9 months. And, but of course, COINTELPRO itself was the mother of all hack and leak operations. Active leftist activists at the time broke into the FBI's headquarters office in Media, Pennsylvania, stole the files, gave them to the media, and newspapers published them. And you're bound to be aware of New York Times Company versus United States, the Pentagon Papers case.
Yes.
That says that even if information has been stolen or inappropriately taken, that you can't get a prior restraint in almost any circumstance to prevent their being distributed. So how is it that your Foreign Influence Task Force is out warning of hack and leak operations to innocent, not involved in the hack, that would be criminal, but news or social media organizations where information may be circulated?
Well, first off, we're not engaging in any prior restraint. Second,
wow.
Second, well, let me, if I could finish, please. Second, there's no serious dispute that foreign adversaries have and continue to attempt to interfere in our elections and that they use social media to do it. President Trump himself in 2018 declared a national emergency to that very effect. And the Senate Intelligence Committee, in a bipartisan, overwhelmingly bipartisan way, by the way, not only found the same thing, but called for more information sharing
Director,
between us and the social media.
I hear you, but it doesn't justify trampling the established First Amendment rights of Americans as the Supreme Court has declared them, whether or not, frankly, I agree with them or you agree with them. And I just don't, that's what I don't get. You come here and the comments are sort of blasé answers. Accountability is always down the road. We never arrives. And I'm not trying, I guess I'm joining the gang up, but what I'm concerned about, and I think Americans are concerned about, is they just never see it. I don't know of an answer other than to take an appropriation from you that's very significant or to do something to take your intel powers away and put them in another agency. I honestly want to know.
Mr. Chairman.
And I think Americans want to know. I yield.